Okay, let's take a look at the legalities of this ruling. We're now joined by Elton Hart, a legal analyst. Elton, thank you very much for your time this afternoon. So what should we understand of this? Because the court says that Zuma is not allowed to reinstitute proceedings with or take any further steps in the matter. And there you hear the Jacob Zuma Foundation saying they will appeal the ruling.
Now, obviously, if one looks at what has happened, because the High Court gave an order, but there's nothing stopping the former president from approaching the full bench of the High Court or maybe the SCA for leave to appeal. Obviously, he will go for leave to appeal to that judge that made the ruling, and if he denies it, he will go to the full bench or the SCA. But nothing stops him from actually appealing the decision. And when that appeal is lodged, then it means that we are back to square one, where it means that a higher court will have to look at, was the judgment in the interest of justice, and did they look at every avenue and every aspect pertaining to this? Because one should not forget, the NPA gave a nolli prosecute certificate in regards to Advocate Billy Downer to say that they declined to prosecute. They did not say that there is not a case to answer when the NPA issued that certificate. It was not so clear as to Karyn Maughan, how she is implicated, because that certificate did not clearly state their names, but Advocate Billy Downer was in charge of that docket where the former president is an accused person, where this information was retrieved from. So I think one needs to not, and I see now the media houses is sort of half having sort of a victory lap already. They should rather wait for the appeal, because I know the Jacob Zuma Foundation, how they came out with SMSs and tweets already. They're going to appeal this decision. They're not going to take this one on the chin and lie down. So we should not think that this is the end of this little battle. So we will see what either the full bench or the SCA says about how that private prosecution should or should not happen. Because one needs to also bear in mind, if we say to there's precedent setting that saying that you can actually go to civil court and stop your criminal prosecution, that can also open up another can of worms in terms of the South African law.
Let's expand on that, because in fact we do have the Jacob Zuma Foundation on record telling Newzroom Afrika they will be appealing. And so are you saying there are grounds for appeal?
No, obviously, be it weak or strong grounds, I have not seen the entire application of the Jacob Zuma Foundation or the application that was brought by the applicants in this regard. I had snippets of the application, but hearing the arguments, then one can sort of have drawn. And I don't think that there is no room. Maybe they might not clearly say that Karyn Maughan is drawn into this private prosecution, but obviously Advocate Billy Downer, surely he should be in that, because he was the custodian of that criminal docket where the former president is implicated. He was the custodian of that documents, keeping it safe. And obviously they're saying that these documents, being part of a case document, becomes public document, but it's not actually correct, because remember, you get access to the state's docket to a certain extent. You don't get access to everything in that state's docket when they're going to present you a case in criminal court. So that is not 100% correct what they're trying to portray in the media to say that it was a public document. I sort of have, especially if the person says, I do not give consent that my document be disclosed to the public, because although I disclose it for you for a specific trial purposes, it should be used for that purposes only and not outside to be in newspapers and stuff like that. So I see that there is a 50-50 chance that this decision might be overturned.
You spoke about in the eventuality this is taken up and the matter goes back to square one, it could open a can of worms in terms of legal processes. What does that mean?
Obviously, if, say for instance, the Supreme Court of Appeal said, listen, yeah, it's right, the application, it was correct, what the judge said in the High Court, and it stands, then for other criminal cases, now it means people that's currently being criminally prosecuted for any other crimes by the NPA, they can follow a similar route to actually approach a High Court to say, listen, yeah, I'm being charged criminally, interdict the NPA from prosecuting me. So we should be very careful about what type of decisions and judgments we bring out, and look at, is it in the public interest? Is it not better to just rather say, let this matter go to criminal court, let it be ventilated, and when that man is exonerated, then it's only for that specific case, not to get a general precedent sitting there. Say, okay, people accused of a crime, you can now follow the civil court route and actually get rid of your charges.
When a court says you are not allowed to reinstitute proceedings or take the matter or take any further steps in the matter, one, is that unusual? Two, why?
No, it's not unusual. It's just like saying, sort of giving an interdict to say, listen, you cannot take any further steps in prosecuting them. But it doesn't say you should not take any further steps in appealing. That's a total, the court can never tell a person not to appeal a ruling that was made by that court, because then it means that you actually violating a person's constitutional rights. So the court says you cannot do anything further in the prosecution of Billy Downer and Karyn Maughan. But it's not saying that he cannot approach a higher court to actually now go and appeal this ruling. Because if the higher court comes and says, whatever judgment was made by the higher court, we set it aside and we replace it with a new order, then that new order is in place. And it might be that that order says, no, you can proceed, and the private prosecution, everything is in order, the certificates is there, and then you will prosecute them. You will start, or you will continue with the prosecution where they left it off.
You mentioned that media houses should not be celebrating as yet. Newzroom Afrika spoke to the assistant editor at News 24, and he's welcomed the decision and calling it a massive win for media freedom.
I understand where or from what he sees, he thinks that it looks like the Jacob Zuma Foundation is trying to actually suppress the media from actually broadcasting. But one needs to look at the facts surrounding how she laid her hands on the information. I'm not saying journalists should now disclose who their sources is, but at least when you acquire information, let it be through the proper channels. If you see that there's something untoward that can implicate you, then rather stay away from it and try and find a legal way of actually getting the information. And I think that is where the problem lies pertaining to Karyn Maughan as to how she got a hold of the documents. It was not in the public domain. It was given to the prosecuting authorities so that they can see if he really went for a medical check at a Military One hospital. And that document was supposed to be used for that purpose only, and not disclosed for any other purpose. So one should not be getting drawn into these technicalities, because that's technical things that happen behind the scenes. And it's just about, so for the media houses, I understand that you want to protect the journalistic freedom, but one needs to check beyond that. Was there something that is contrary to our constitution and our prevailing laws that was done to acquire that information? There is where we would look at if we have a problem there. But I also support that the media should be, without fear or favor, reporting on anything and everything, but just make sure that the information we get it to the proper channels.
Elton Hart is a legal analyst. Thank you very much for your time.